Hello friends, welcome to Learning Sessions, and in this video we are going to talk about the very important concepts related to the CAIIB. If you have not subscribed to our channel yet, do subscribe the channel at the earliest and press the bell notification icon so that you get updated whenever we upload the new videos over there. And let me tell you one thing, if you want to get the free PDFs for the CAIIB, in that case particularly visit the link that is available on the screen right now, and also you can actually be downloading the PDFs. Just WhatsApp us writing #CAIIB PDF and WhatsApp it to the number 83609444207, and we will be sharing the free PDFs link to you. So do hurry up and do join the courses, and that will be related to this. So do watch this video till end because this is actually a game changer video for you.
So first it is regarding check. So till now we studied the Reserve Bank of India Act, the RBI Act, and further we also studied the different sections of Banking Regulation Act. So one important act that we will be learning in upcoming videos, that is regarding the Negotiable Instrument Act. That is regarding Negotiable Instrument Act 1881. That is regarding the Negotiable Instrument Act 1881. Whether it is check, whether it is promissory note, whether it is a bill of exchange, all are defined under the Negotiable Instrument Act. Okay, and you need to remember those sections. So it is regarding 4, 5 and 6. 4, 5 and 6. In section 4 of the Negotiable Instrument Act, promissory notes are defined. In section 5 of the Negotiable Instrument Act, bill of exchange is defined, and further in section 6 check is defined. And further, if we look at the definition of the check, a check is none but a bill of exchange. Check is none but a bill of exchange. So check is a bill of exchange which is drawn on some specified bank. So there are how many parties in case of check? There are 3 parties. There are 3 parties in case of check. Okay, so one, it is the drawer who is maintaining an account with the bank, and a check is always drawn on a bank. So in case of check, drawee will always be the bank. Drawee will always be the bank. And the third party, it is the payee. Third party, it is a payee. Okay, and by virtue of the negotiability, other parties come into the picture. We will be discussing it later, but mainly 3 parties are there. Okay, mainly 3 parties are there. Drawer, which is an account holder, which is maintaining an account with the bank, and drawee is the bank where he is maintaining the account, and pay is the person to whom drawer wants to pay ultimately. Okay, so that is the case. So section 6 of Negotiable Instrument Act defines a check as a bill of exchange which is drawn on a specified bank and not expressed to be payable other than on demand. And further, the act covers electronic check also. So once there was the modification or the Information Technology Act came into picture, the CTS system was there. Check truncation system is available now, and due to which electronic checks are also available, and further the Negotiable Instrument Act was also modified. Okay, so that is the case. Next, it is regarding the relationship between banker and customer, being debtor and creditor relationship. Now if person A is maintaining a saving fund account with bank XYZ, in this case XYZ, there is obligation on bank XYZ to pay back the deposited amount to the person A on demand. Okay, so that is why it is said to be that relationship between a banker and customer, being debtor and creditor relationship, that the bank is bound to pay the checks drawn by his customer if the check is otherwise in order. Okay, if the check is otherwise in order, and the person is maintaining the available balances, the operable balances in the account. Now it is regarding the amount of a check. It is regarding amount of a check. So there are amount is mentioned twice in the check. Amount is mentioned twice in the check. It is mentioned in figures as well as in words. It is mentioned in figures as well as in words. So if a person wants to pay person B rupee 10,000, rupee 10,000. He mentions it in figures also and also in words like 10,000s only. 10,000s only. Okay. Now, if the amount in figures and words differ, if the amount in figures and words differ, let us say he omitted to put the other zero. There should be 4 zeros in 10,000, but he omitted to do so. So in that case, the one in words will prevail. The one in words will prevail. The instrument will be paid accordingly to the words. According to the words. And further, if any of it is not mentioned, that only in words is written in the check and in figures it was not written and was omitted, in that case it is an inchoate instrument. It is an inchoate instrument, means incomplete instrument, and shall not be paid. And shall not be paid. I'm repeating it again, that when amount in figures and words differ, in that case the payment will be done as per the amount written in words, and where the amount in words only in written or amount in figures only in written, in that case it is an inchoate instrument. It is an incomplete instrument which is defined under section 20 of the Negotiable Instrument Act and shall not be paid. Okay. Next is regarding the bearer or order check. What is bearer check? What is bearer check? Bearer check is equivalent to cash. Bearer check is equivalent to cash payment. It means if person A gave a bearer check to person B, and person B lost this check and person C found this check and he took the payment, he withdrawn the payment from the bank counter. Is bank responsible for that? Is the bank responsible for that? No, the bank is not responsible, because the definition of the bearer check says the holder is the pay. Holder is the pay. Okay. It may be the other case that if C is found because it was illegal, he can be adjudicated under the law, but otherwise the bank is not liable in any case. Okay. So that is a bearer check. If nothing is mentioned on a check being order or bearer, it will be considered payable to order check. I'm repeating it again. If nothing is mentioned on check, see, it is always mentioned, likewise the check wording is like this, that pay, then blank, then it is written over here bearer order. Okay, but we are talking about the scenario where none of this is mentioned, where it is not mentioned in any case that it is a bearer or order check. In that case the check will be considered to be order check. In that case the check will be considered to order check. And further, if we want to convert the bearer to order, it can be done with full signatures. It can be done with full signatures. And further, if both words order and bearer are mentioned and none is deleted, as we mentioned over here, both the words bearer as well as the order word, bearer as well as the order word, both are mentioned in the check but none is deleted, in that case it will be considered as payable to bearer. तो उस check को payable to bearer check माना जाएगा. And if you want to convert the order check to bearer, it is allowed with full signature. It is allowed with full signature. Then it is regarding very important concept, that if the check is drawn in different ink, if it is drawn in different ink, different language, different scripts, different handwriting, such checks will be paid if otherwise in order. If otherwise in order but in different ink, different language, different scripts, different handwriting, it shall be paid. It shall be paid if otherwise in order. Okay, so if A drawn a check where he mentioned pay name to Amar, he mentioned in green ink, let's say pay Aman, and further amount mentioned in black ink, 10,000 only, then it could be the case that signed in blue pen ink. Is it valid? Yes, that is valid check. That is a valid check. But what if the check is drawn with a pencil? What if check is drawn with the pencil? Will it be a valid instrument or not? Will it be a valid instrument or not if the check is drawn with pencil? Kindly confirm, kindly answer. If a check is drawn with the pencil, in that case, would it be a valid instrument or not? It will not be. It will not be a valid instrument. Okay. Then it is regarding dates in checks. Dates in checks. Very, very important concept again. Very, very important concept again. First of all, it is regarding undated check. Undated check means the date is not mentioned on the check. The date is not mentioned on the check. If the columns on the check are not filled in properly and the check is incomplete, the instrument is incomplete, it is said to be inchoate instrument. It is said to be inchoate instrument, which is mentioned as per section 20 of the Negotiable Instrument Act, which is defined under section 20 of the Negotiable Instrument Act. Further, if the check is bearing a date on holiday, can it be paid? Yes, it can be paid. If check bearing date on holiday, in that case it can be paid. Further, if check is bearing impossible date, if a check is bearing impossible date, like if 29th February 2019 is mentioned on the check, would it be paid? Yes, it will be paid on the previous day. It will be paid on the previous working day. And what is antedated check? What is antedated check? Date prior to actual date of signing is valid check. Date prior to actual date of signing. So let me mention a case over here also. So person A opened an account with bank XYZ, let us say on 1st of March 2021. So person A opened an account with XYZ bank on 1st of March 2021 and he received the checkbook on the same day. And he received the checkbook on the same day and he drawn a check amounting rupees 10,000. He drawn a check amounting rupees 10,000 in the name of person B, dated 26th of February 21. What check it would be? It is antedated check. It is antedated check because it is drawn date prior to actual date of signing, but it is valid instrument and the validity period will start from the date mentioned in the instrument, and the validity period will start from the date mentioned in the instrument itself. Okay, and what about stale check? What about stale check? If the validity of the check is expired on the date present, on the date of presentment, then it is stale check. Then it is termed as stale check. And what is the validity period of the check? It is 3 months. Validity period of the check is 3 months. Previously it was 6 months, but under section 35 of Banking Regulation Act, it was reduced to 3 months by the Reserve Bank of India. It was previously 6 months, but now reduced to 3 months as per section 35A of the Banking Regulation Act. Okay. Then further it is regarding stale check can be revalidated any number of times, and validity of the revalidated check will start from the date of revalidation. Stale check can be revalidated any number of times and the validity will be starting from the date of revalidation. Then it is regarding PDC. PDC, normally termed as PDC, post dated check. Post dated check. So a check which bears a date later to the date which it is drawn, that will become effective on the date mentioned. Are PDCs valid? Yes, the PDCs are valid. So if person A gave a check to person B and we are assuming today, let us say today it is 7th of March 2021. 7th of March 2021. Okay, and but on check person A mentioned date to be 5th of May 2021. Now this check will become valid from 5th of May 2021. It will become valid from 5th of May 2021. And further, the drawer can stop payment before the date of instrument. Drawer can stop payment before the date of instrument. So if you receive a PDC, is it secure? Is it secure? No, it is not secure. But still, after the validation, you can sue the person. If you have legally received the check, you can sue the person. Okay. Then it is regarding the Negotiable Instrument Act 1881 lays down the laws relating to payment of a customer's check by the banker and the protection available to the banker. Now, who is a paying banker? Who pays the amount to the customer? That is a paying banker. Is it so? Is it so? Yes. Yes, it may be the case. Okay. So, if person A drawn a check and gave it to person B, person A's bank means the drawee is XYZ bank, and person B deposited this check with bank ABC over here. Person B deposited the check with person ABC over here. Now ABC will be acting as an agent over here, and the person B is acting as a principal. Person B is acting as principal because ABC is going to collect the check on behalf of person A over here. So person A will furnish this check under the clearing or under the CTS and will be getting the amount from the concerned bank. In that case, who would be the paying bank and what would be the collecting bank? Now ABC is acting as collecting bank. ABC is acting as collecting bank. Okay, and XYZ is acting as over paying bank over here. It is acting as paying bank over here. Okay, now we are going to talk about the protection to a paying banker in this class particularly. We are going to talk about the protection to paying banker in this class particularly. So section 10, you need to memorize these sections. That's section 10, section 85, 85A, 89 and 128 of the Negotiable Instrument Act grant protection to the paying bank. They grant protection to the paying banker. Is it clear? So what these sections stipulate, we will look into it. So now let us jump to the section 31 first of all. Section 31 says what? Section 31 says it is a statutory obligation to honor customer's check. As we discussed in the definition of the banking itself, under section 5B of the Banking Regulation Act, it says banks accept deposits from the public for the purpose of lending and investment. But this deposit so accepted is to be repaid on demand by check or by otherwise, or order or otherwise, or by demand draft. Okay, so it is a statutory obligation on the bank to honor the check subject to those conditions. And what those conditions are? First of all, it should have a sufficient funds. The banker should have sufficient funds of the drawer. So there should be sufficient credit balance in the customer's account. The first condition says there should be sufficient fund. Second, it says it should be properly available. What do you mean by properly available? It should be the clear balance which is available. That should be available. The banker should have the right. The banker should have the right so as to exercise the balance. So as to exercise his right to debit the balance in the account. Okay, what if A had previously rupees 50,000 in his account, and he drawn a check amounting rupees 25,000 in the name of person B. Okay, and in the meanwhile, A garnishee order, which we will be studying about in later on, which we'll be studying on later on. A garnishee order or an attachment order is received in the account, think to block such sum of account amount rupees 30,000. Rupees 30,000 is now blocked in the account. Or it may be the case that bank has exercised its right of set off. Bank has exercised its right of set off so as to set off the amount due from the customer itself. It may be also be the case now that bank is also the customer A is also has borrowed a sum of money rupees 1 lakh from the bank itself, which was due. Now there is balance in the account, so bank may exercise his right of set off, okay, so as to recover its amount due. Okay, so in all these cases, the clear balance of 50,000 is not now available. So it is said that the balance which is available, the funds which are available should be properly available. These should be properly available. Third point, it says compensate the borrower. See, if all the conditions are fulfilled, but yet bank refused the payment wrongfully, then he is liable only to the drawer of the check. There could be the multiple parties. As we discussed earlier, I told you that there are three parties: drawer, drawee and payee. But it could also be the case that person A drawn a check in the name of person B, but it also be the case that B endorsed this check in the name of person C, and further C in the name of D. So there are multiple parties involved now. So there are holders, there is holder in due course, or we can say endorsers or endorsees available now. Okay, so what if the check was presented now by person D and the check was refused wrongfully by the drawee? So the check was refused wrongfully by the drawee. In that case, the bank refuses payment wrongfully, then he is liable only to the drawer. So means the bank in this case is liable only to the drawer. If there is any compensation to be given, that would be provided, that would be given only to person A, and bank is not concerned about these parties. Bank is not concerned about these parties. If the bank is to compensate, bank will compensate person A over here. Okay, so that is the case. So we learned about section 31 over here, that is obligation, statutory obligation to honor customer's check. Then it is regarding protection to paying banker. So one of the main factors for protection under the negotiable instrument is the payment in due course. We will be repeating or reiterating this term again and again. That is section 10 of the Negotiable Instrument Act, that is payment in due course. Payment in due course means payment to be made in accordance with the apparent tenor of the instrument. You are paying as per it is mentioned on the instrument itself. The banker is paying as per it is mentioned on the instrument itself. If it is an account pay check, then it should not be paid on the counter, across the counter. If the amount of rupees 10,000 is mentioned, then the rupees 10,000 only should be paid. If it is an order check, then you need to look into the proper order or the proper endorsements over there, and further the check should be paid in good faith. The check should be paid in good faith, and there should be no negligence in this case. And further, the amount should be paid to the person in possession of the instrument. The amount should be paid to the person in possession of the instrument, and while making the payment, the banker should not have any reason to believe that the person in possession of the instrument is not entitled to receive the payment. So if there is a point to believe that the payment should not be made to this person, or the check holder does not seems to be the right owner of the check, in that case, or not entitled to receive the payment, in that case payment should not be made. So if all these conditions are met, that the check is that the payment is made in accordance with the apparent tenor of the check, in good faith, without negligence, if all these conditions are met, then it is said to be payment in due course. Let me tell tell you, we studied about section 4 regarding promissory note, section 5 regarding bill of exchange, section 6 was regarding checks, then we studied about section 10, that is payment in due course, then we studied about section 20, which was related to inchoate instrument. Okay, so I will let you know which important sections you need to memorize, and further we also study about section 31 regarding the statutory obligation on the bank to pay the check. Then it is regarding section 85 of the Negotiable Instrument Act, that grants protection to a banker on his making payment of a check. So it says, where a check payable to order purports to be endorsed by or on behalf of the pay, the drawee is discharged by payment. Let me explain it to you with an example. So, person A drawn a check and ordered to pay to B, ordered to pay a sum of amount of rupees 10,000 to person B, and person B endorsed this check in the name of person C, and for this purpose the endorsement is to be done by person B. Endorsement is to be done by person B on the face of the check or on the back of the check, or it could be also an extra slip that is attached to the check where endorsements can be made, that is said to be a launch. Okay, so any number of endorsements can be made. So let us say C endorses this check to D, and D to E, and E to F, and E to F. Okay, so what does it say? It says, where a check payable to order purports to be endorsed by or on behalf of pay, the drawee is discharged by payment. It means the drawee only needs to check whether the endorsements are regular or not. What does it mean? It means the endorsement should be like B endorsed to C, C endorsed in name of D, D in name of E, and E in name of F. If the order is like this, that the endorsements have been made in this way, then it is said to be regular endorsements. And the paying banker is not concerned regarding the signatures. It is only the regularity which the bank is concerned about, which the paying banker is concerned about, and it is not about the signatures. Okay, so if there is regularity in the endorsement, then the paying bank is discharged by payment. Okay, where a check is originally expressed to be payable to bearer, the drawee is discharged by payment in due course, because once a bearer is always a bearer. So if say it was an order check, then the regularity of endorsement is necessary. But if it was a bearer check, let us assume in the second case, if it is bearer check and it was passed on, and further there was no endorsement from D to E, now also the paying banker is discharged from its liability, because in case of bearer check, the endorsements are of no use. Because once a bearer is always a bearer, so bearer check में आपको endorsements को check ही नहीं करना. Okay, so that is covered under section 85. And section 85A stipulates the same about the drafts. Section 85A stipulates the same about the drafts. And further, section 89, again very important, protection to paying banker. कौन से sections हमने cover किए? Which sections did we cover? Section 10 it was payment in due course. Then it is section 85 that grants protection to banker regarding the endorsements, and then it is section 85A, then section 89 that is regarding the payment of instrument on which alteration is not apparent visible. Payment of instrument on which alteration is not apparently visible. So whether it is a promissory note or bill of exchange or check, if it is materially altered, if it is materially altered, but it does not appear to have been altered with naked eyes, आपने अपनी आंखों से देखा, आपको ऑल्टरेशन नहीं नजर आ रही है, ठीक है, you have performed your due diligence, you have performed your due diligence, but the alteration does not appear. In that case, such payment shall not be cautioned by reason of instrument having been altered. Okay, that is also protection to paying banker. That is also protection to paying banker. Next is regarding liability of paying banker when customer's signatures on the check is forged. When the customer's signatures on the check is forged. But before that, we will be covering section 128. Before that, we will be covering section 128. That is regarding protection to paying banker for crossed check. For a crossed check, if the payment is in due course, the paying banker gets protection. If for a crossed check, if the payment is in due course, the paying banker gets protection. For example, A drawn a check, crossed paying to person name Sham over here. Person name Sham over here. Okay. But now this check was lost by person Sham, and another person coincidentally named Sham found this check and deposited this check with his bank. Okay. Now the bank collected the check from the bank of person A, that is a drawee, and the payment so collected was paid by the drawee in good faith and without any negligence, because the instrument was paid in due course. Because the instrument was paid in due course, person A wanted to cross pay the check to Sham, and the payment is also made to person Sham. Now how the paying banker can differentiate if it is the original Sham or not? Okay, so the paying banker will get a protection in this case also. Paying banker will be getting a protection in this case also. That is covered under section 128. Now what if the signatures of a customer is forged? It may also be the case that person A had the checkbook, which was lost by him, or some of the check was stolen by person B. Let us say person B stole the check from person A over here and forged his signature. In that case, if the signatures are forged, there is no mandate by the customer. Even if the signatures were in a way that those were apparently the same as that of person A. In that case also, it was not a valid mandate. And the bank was not mandated to pay in that case. And such case, the banker is not entitled to debit the account of person A. In that case, the banker is not entitled to debit the account of the depositor, because the signatures were forged. There was not a valid mandate and the banker was not entitled. So that would be a liability on the bank. Paying bank. Okay. Since the relationship between the customer and bank is that of creditor and debitor, so bank will be having no authority to make payment on check containing a forged signature, even if in the case of the joint account. So A and B are maintaining a joint account, jointly operated account, and both needed to sign the check. And A signed originally, and the signatures of B were forged. B's signatures were forged. Would it be a valid mandate? No. ये भी एक valid mandate नहीं होगा. This will also not be a valid mandate, and the paying banker will be liable in this case also. So paying banker will be liable in this case also. Next is regarding payment in good faith without negligence of an instrument on which alteration is not apparent. On which alteration is not apparent. We already covered these sections, so I will not be repeating these sections again. Next topic we are going to cover is regarding the check truncation. Check truncation. So previously what happened, the checks were needed to be presented in the clearing houses. They were presented in the clearing houses and the physical movement of checks were there. So truncation is the process of stopping the flow of the physical check issued by a drawer. So if a physical check is issued by the drawer, so truncation is the process by virtue of which the physical flow is now stopped. So in the place of a physical check, an electronic image of the check is transmitted to the JAIIB branch. An electronic image of the check is transmitted to the JAIIB branch through the clearing house. So all the relevant information like the data on the check, MICR band, date of presentation, presenting bank, etc., all this information is also mentioned along with it. So electronic image now transmitted to the JAIIB bank. So check truncation thus obviates what? It stops the physical movement of the instrument. So physical movement of the instrument is now stopped, and further now you can effectively manage the cost associated with the movement of the instruments. Okay, further it reduces the time required for their collection and streamlines the entire activity of the check processing. Is it clear? That is the concept of the check truncation. So as we already discussed, it is regarding section 85A and 85(1). We already discussed that that is regarding the endorsement. So there are some facts regarding the endorsements. The genuineness of the endorsement is the liability of the collecting banker. The genuineness of endorsement, that it is, if it is a genuine endorsement or not, it is the liability of the collecting banker. The paying banker is concerned only and not only about the regularity of endorsements. It is concerned about the paying banker is concerned about only and only about the regularity of the endorsements. So payee or endorsee of a bill must himself or agent appointed by him should sign the endorsement. So those only will be signing the endorsement. Payee or endorsee or their agent. Payee or endorsee or their agent must be signing the endorsement. And further, no endorsement should be in capital letters. Like if Amit wants to endorse the check to Priya, the signatures should not be like in uppercase. So should not be in capital letters. Signatures should not be in capital letters. And further, if the instrument is payable to two persons, then both of them must endorse in their handwriting. If the check was payable, let us say the check was payable to originally to Amit and Priya jointly, in that case, if they want to endorse the instrument, in that case, the endorsement to be made by Amit and Priya separately in their handwriting, and spelling of the name of the endorsee must be same as appearing on the instrument. If the Amit signatures appear to be Amit name is appear on instrument in the payee as Amit, so Amit is to sign the endorsement in the same signatures, in the same spellings, Is it clear? In that case, Amit and Priya will be endorsing the instrument in the same spelling as appearing on the instrument itself. Okay, section 10 we already covered. So these were the instruments that provide protection to the paying banker. कौन से section से? Let us just repeat. Section 10 was regarding the payment in due course. Let me repeat all the sections. From the starting itself. Okay. So section 4 we covered. जल्दी से बताएंगे सेक्शन 4 किससे रिलेटेड है, सेक्शन 5 किससे रिलेटेड है, सेक्शन 6 section 10, section 20. So first of all, section 4, it is related to which one? Section 4 is related to promissory note. It is related to promissory note. Very good. Section 5, it is related to bill of exchange. Section 5, it is related to bill of exchange. Section 6, it is related to check. So check is a type of bill of exchange. Okay. Section 6 is related to check. And then it is regarding section 10. Section 10 is related to payment in due course. It is related with payment in due course. Then it is regarding section 20. Section 20 is related to inchoate instrument. It is related to inchoate instrument, means incomplete instrument. Then it is section 31. Section 31, it deals with liability of the dry. Section 31 deals with the liability of the dry for wrongful dishonor. It deals with the liability of the dry for wrongful dishonor of the instrument on presentation. Now, which sections were regarding the protection to paying banker? तो प्रोटेक्शन टू पेइंग बैंकर के रिगार्डिंग कौन कौन से सेक्शन थे? Which sections were there regarding the protection to paying banker? First of all, it was section 10, payment in due course. Then section 85 was there. Then section 85A in case of drafts regarding the endorsements. And further, it is regarding the section 128, payment of crossed checks. And then regarding section 89 also. Section 89 also, that if the check is materially altered but not visible with naked eyes, in that case also the paying banker gets protection. So these all sections are concerned with the protection to paying banker. Is it clear? Okay. Next it is regarding when bank should not pay. When bank should not pay. So let us understand with this an example. So person A is maintaining a saving fund deposit account with bank XYZ. Person A is maintaining saving fund deposit account with bank XYZ over here. Okay. And further, he drawn a check in the name of person B over here amounting rupees 10,000 dated 1st of February 2021. He drawn a check amounting rupees 10,000 dated 1st of February 2021. And the check was presented by person B dated 20th of February 2021. And I'm not considering this as a holiday because I have not checked the calendar yet. So let us assume 20th of February is not a holiday. And it was presented by person B on 20th of February 2021. Okay. And it was presented with the same bank. Let us say B was also maintaining account with bank XYZ over here. So he presented the check to bank XYZ over here. And further, it was in the notice of bank XYZ that person A died dated 15th of February 2021. It was in the notice of the bank that the person A died dated 15th of February 2021. In this case, the check should be paid or not? The instrument should be paid or not? Kindly do answer. Kindly answer fast. So the scenario is clear that the check was drawn by person A in the name of B dated 1st of February 2021, and further the check was presented dated 20th of February 2021, dated 2021 February 20th, but in the meanwhile the person A died dated 2021 February 15th, and it is in the notice of bank XYZ. Should it be paid or not? Should this instrument be paid or not? The instrument will not be paid and is not to be paid. The instrument not to be paid. When it is an individual account, when we are talking about an individual account, whether it is a saving fund account or it is a you can say proprietorship account, the account should not be debited because the relationship between the bank and the customer ceases. Because the relationship of the bank and the customer ceases. So the amount will not be paid. The amount will not be paid on presentation of the check by person B over here if it is in the notice of the bank that person A died. Okay. So when the bank should not pay? When the bank should not pay? On the death of the drawer itself. The death of the drawer in case of individual account, whether it is a proprietorship account or it is a joint account, HUF account or partnership firm account, because it terminates contractual relationship. Because it terminates contractual relationship. And further, if the company is in a liquidation, we already learned about winding up of the bank. We already learned about the winding up of the bank. If the banking company or any other company is in the process of liquidation or winding up, in that case also the check is not to be paid, because the assets and liabilities of the company are now vested with the official liquidator. Once a company is under liquidation, the balance, or we can say assets or liabilities of the company, vest with the official liquidator, and the amount of the check is not to be paid by the banker now. Okay. Same goes for the insane customer. The insanity terminates the contractual capacity. The insanity terminates the contractual capacity. Okay. And further, if it is a case of the insolvent drawer, where the customer is adjudged insolvent, the balance in the account is vested with official receiver or assignee, and the bank should stop the operations in the account. If the person is adjudged insolvent, when I say adjudged insolvent, it means a court order regarding the same has been received, and the account balance or account assets and liabilities are now vested with the official receiver or assignee. In that case, the account operations should be stopped. And it could be the normal case regarding countermanding. It could be the mandate from the customer itself. So on receipt of valid stop payment instruction from the drawer itself, the check should not be paid. And what if a partnership account ABC? What if in a partnership account ABC, a check was drawn by them, and instructions of stop payment were given by person A. Instructions of stop payment of the check or countermanding the check were given by person A individually. In this case, the check payment should be stopped or not. I repeat, it is a partnership account where ABC jointly drawn a check, but A individually gave the instructions regarding stop payment. Should the payment be stopped or not? Should the payment be stopped or not? Yes, the payment is to be stopped. Now, if they want to reinstate the status of the check, means they want to they want the check to be payable again. If after the stop payment instructions by individual person, the payments can be stopped, is it possible to reinstate the status of the check after giving the instructions? So we can say if the instructions to stop payment the check were given by person A individually over here, and A now wants the check to be repayable again. It can be done by individually person A or not. It can be done individually by a partner or not. No, it cannot be done individually. It is to be done with the consent of all the partners. It is to be done with the consent of all the partners. Okay, that is regarding the stop payment. And further, other cases where the check is not to be paid, when the check is post dated or the balance fund is not sufficient, or the check is of doubtful legality, or the funds in the banks are not properly applicable for the payment. As in the case, it may be the case that garnish order or attachment order is received in the account, or it could be the case the check is not regular or is ambiguous, or it could be the case that the check is altered, okay, or it could be the stale check. In all these cases, the check is not to be paid. In all these cases, the instrument is not to be paid. So friends, that would be regarding this video.
So I hope that you must have liked the content of the video. So if you have liked the content of the videos, do give it a thumbs up, and further, do share the video among your friends and colleagues who have been preparing for CAIIB, and do not basically miss the course which is actually available. It's actually a pro course and you need not to go through anything else other than this particular course over there. So do hurry up and enroll in the course right now and start preparing for the same.